Mabuhay ug madayaw. Good morning, everyone. For this presentation, I will be presenting to you the topics regarding the volunteer probation aid case assignment procedures up to board composition. So the first one is here is the how the cases are being assigned to volunteer probation aids. So the first step is to find the suitable match of VPA and client, of course. Since they are going to work with each other, you have to really find the suitable person to undertake or to supervise that specific client. And also, the second one, the supervising officer informs the VPA and the client individually of the program and process the planned assignment of the case to the VPA and explains the program and the process. So here, you should inform them individually, not dili siya sabay. So you have to do a one-on-one interview with both of them so that you are able to explain what are the programs that they are going to undertake, and you are able to explain to the VPA what are the things that he is going to supervise with the client. And the third one is the CPPO assign cases to the VPA under the charge of the supervising officer by way of an office order. So since you are able to find the suitable match and you're able to inform them individually about the programs, therefore the chief probation and parole officer are going to release a office order stating that that specific VPA assigned to this specific supervising officer to undertake the supervision of that specific client. And also we have here the fourth one. The supervising officer formally introduces the client and the VPA to each other. So this is the time wherein the VPA are able to meet the client, and also the client are able to meet the supervising volunteer, no, that is going to supervise him during the period of supervision. And we also have the VPA conducts initial interview to get to know the basic information and circumstances of the client. So here, of course, as a volunteer probation aid, you have to know the basic informations regarding your client. You have to know their names, age, where do they live, and all the basic informations that you must know. We also have here the VPA and client make tentative plans and undertake the supervision process. So the VPA and the client are going to work with each other to make tentative plans on how they are going to go through with the supervision process. And the next one, the VPA takes time to study client records, investigation notes, and payment plans. So as a volunteer probation aid, you should study the records, the circumstances of your client so that you're able to understand their situation. And also the next one is the VPA conducts subsequent supervision interviews and periodic house and workplace visits. Of course, as a supervising aid or as a volunteer probation aid, you must, of course, conduct consistently interviews regarding your client, and also conduct house visits and workplace visits. And the last one is the VPA attends and performs allied supervision activities and accomplishes VPA monthly report. So here, the volunteer probation aid must assist the client in all activities that he is going to undertake during the supervision, and also he must accomplish the volunteer probation aid monthly reports. And here we have the last part of my report, which is the suspended sentence. So it is an alternative or imprisonment where a judge may partially or entirely suspend the convicted individual's prison or jail sentence so long as they fulfill certain conditions. So PPA has an added task of conducting investigation of first-time minor drug offender to apply for suspended sentence under Republic Act 9165 or the Comprehensive Dangerous Drugs Act. So when we say suspended sentence, it is within the supervision of the judge, where he may suspend entirely or partially your sentence, as long as you're able to meet or you are able to comply with the conditions given by the court towards you. And also, the Parole and Probation Administration conducts investigation specifically for those first-time minor drug offenders, so that they are able to apply for suspended sentence under the RA 9165, or the Comprehensive Dangerous Drugs Act of 2002. And I am going to give the floor to the next reporter, which is Mr. Muñez. Thank you.
Good morning, everyone. I'm Ian Dave Muñez, and I will be the one who will report about the suspension of sentence of a first-time minor drug offender, case for disposition conference, discharge of a first-time minor offender, and voluntary confinement. First, suspension of sentence of a first-time minor drug offender. So, what is a first-time minor drug offender? This is someone who is over 15 years of age, but not more than 18 years of age, that is committed for the first time in a violation of that involves illegal drugs. So the suspension of sentence, the privilege of the suspended sentence shall be waived only for once by an accused drug dependent who is a first-time drug offender over 15 years of age at the time of the commission of the violation, but not more than 18 years of age. So the conditions of this privilege is that he or she not been previously convicted of any provisions of Dangerous Drugs Act of 1972. He or she has not been previously committed to a center to the care of DOH accredited physicians, and the board favorably recommend that his or her sentence be suspended. Sa conditions, it means that dapat wala siya na convict, previously convict. So dapat, as it said sa title, dapat first time drug offender yun siya jud. So dapat wala siya na convict of any violating provisions of Dangerous Drugs Act of 1972. Then dapat wala sad siya na kanang commit, o wala sad siya na handover sa center of care sa DOH sa physicians. So it means that yun nga, dapat first time jud siya nga minor drug offender. Also, kanang kailangan sad nato, dapat kailangan sad na convince ang board or ang mga nagbuot sa nga dapat i-suspend ang iyang kanang sentence. So case for disposition conference held by the court to determine the appropriate rehabilitative plan for a minor who has been found to have committed an offense. These are the kanang mga treatment. So si court jud mismo ang magbuot sa kung unsay mga dapat mga plano for the rehabilitative plan. So rehabilitative plan mo siya ang plans nga or mga activities nga ginabuhat for ginahatag nga mga plano for someone who is committed for a offense. So mo siya mga ginahatag na service, no? So care, guidance and supervision orders, community service orders, and drug alcohol treatment sa mga may bisyo dyan and mga addicted sa drugs and alcohol. So participation in group counseling and similar activities. And the last one is commitment to the Youth Rehabilitation Center of Department of Social Welfare and Development, or DSWD. So in this kaning rehabilitative plan, no, so mao ni siya mga part sa rehabilitative plan niya para mabalik sa community ang isa ka, let's say kanang murag na saag sa landas, sa tamang landas. So dapat mo ni siya mga gina-apply for someone na makabalik siya sa atong community na harmless na dyan. So next is discharge of a first time minor offender. So mingon tag minor offender no kay mao ni siya mga nakakommit og mga crime nga below 18. So if the accused compliance with the applicable rules and regulation of DDB or Dangerous Drugs Board, he or she be discharged and dismiss all proceedings. So kung mag-comply siya sa rules and regulations sa nga gihatag sa Dangerous Drugs Board no, kay pwede na ma-dismiss or ma-discharge siya sa mga kanang mga kuti-kuti pa like mga further proceedings or unsa ba. So the child shall be brought before the court for execution of the judgment if the court finds that child is so if kanang naay mga butang kanang mga condition nga nakita sa kanang minor nga offender na so kailangan siya dadun sa court for the final judgment. So the conditions are is incorrigible, has not shown the capability of becoming useful member of society, has willfully failed to comply with the condition of rehabilitation program. The child's continued to stay training institution is not child's best interest. So sa madaling salita after the rehabilitation jud no nga na hatag sa iya is if murag wala siya progress after nga gihatag nga services sa rehabilitation after the efforts of the government nga para sa iya if kanang murag dili jud siya murag wala jud siya chance or dili niya tagaan ng chance sa iyang sarili nga mabag-o no. So mo to yung ako kanina nga ikuan jud siya sa court, ipasaka jud siya sa court for his or her final judgment. So last is voluntary confinement. This is an intervention activity where any drug dependent either by himself or through his parents or relative shall apply to the board treatment and rehabilitation. So voluntary confinement, so mao ni siya murag voluntary good sa ikaw or nakay representative like imuhang parent or relative nga mag-apply for you nga para ma-rehab ka. So from the word voluntary kanang murag kusang loob jud na mga gusto ka mabag-o sa imong sarili. So this is also applicable to those who are rehabilitated by the DOH accredited centers but failed to qualify for exception from criminal liability, but instead of serving sentence, they were placed on probation and required to undergo community service. So this also pwede dyan sa applicable siya sa for someone who are undergo in probation. So kanang mga wala sila na sentensyahan sa nga makulong sa institution. So nasa sila sa probation, pwede sila mag-apply for his or her rehabilitation. Thank you, that's all.
Good day everyone. Today I will discuss the indeterminate sentence law, the boards of pardon and parole, and the composition of the board. First is indeterminate sentence law. The law gives a prisoner a range of time, a minimum and a maximum, instead of one fixed number, so the decisions can reflect real change in the prisoner's behavior and rehabilitation progress. Number 1 is convicted of offenses punished by life imprisonment. People given life terms are treated as high-risk cases. They are not eligible because their crimes are considered too grave to allow early release under this fixable scheme. Number 2 is convicted of treason. Conspiracy or proposal to commit treason, crimes that threaten the state's security are excluded. The law bars those who plan or join plots. Third, convicted of misprision of treason, rebellion, sedition, or espionage Even those who knowingly hide or support political crimes or spy are excluded. 4 is convicted of piracy. Piracy involves a violence and a danger at sea and is treated as a severe offense. 5 is habitual delinquency. Repeat offenders who keep committing crimes are considered unlikely to reform quickly. 6 have escaped from confinement or evaded sentence. People who already broke custody rules or ran away are not trusted under the indeterminate system. 7. Violated the terms of a granted conditional pardon. If someone misused a prior chance at leniency, violated the conditions of a pardon, they lost the benefit of future flexible sentencing. 8 is whose maximum term of imprisonment does not exceed 1 year, short-term offenders max 1 year. Number 2, second is the boards of pardon and parole. This board is a review body that studies whether releasing a prisoner early or granting mercy is safe, fair, and deserved. Number 1 is looks into the physical, mental, and moral records of prisoners who are eligible for parole and executive clemency. The board checks medical files, psychological assessments, and behavior reports, including the conduct and personal statements. The decisions rest on a full picture of the person's health, mindset, and character. Number 2 is assist in the full rehabilitation of individuals on parole by way of parole supervision. Beyond deciding release, the board helps plan and monitor support job, helps counseling, and check-ins. Third, recommends to the president the grant of any form of executive clemency. The board acts as a filter and advisor. They research cases and advise the president whether mercy, pardons, commutation, or reprieves. The third is board composition. The board is intentionally mixed with people from different backgrounds, so every clemency or parole decision is balanced by legal, social, moral, educational, and correctional perspectives. Number 1 is the administrator of the parole and probation administration. This person brings practical knowledge of how parole and probation systems actually work, including supervision logistics. Number 2 is a sociologist. The sociologist explains how a prisoner's social background, family, community, poverty, peer groups. Number 3, a clergyman. The clergyman offers a moral and spiritual insight about repentance, ethics, and community reintegration. Number 4 is an educator. The educator assesses learning, skills, training, and the prisoner's potential to benefit from educational programs. 5. A person with training and experience in correction work. This member knows prison realities, security, rehabilitation programs, staff constraints, and can judge whether institutional reports reflect real change. 6. A member of the Philippine Bar, a lawyer, ensures each decision follows legal standards and rights, checks due process, and helps the board interpret laws and precedents correctly.